reality is we have a first inventor to file with a grace period, and no other country except, you mentioned Canada, I don't know. So we're keeping our grace period. Congress really thought that was important. It's in the legislative history. They really wanted that in there. So we have a modified first to file system coming up. So why do we care? Filing dates are now more important than invention dates. I saw a lot of hands go up when Siva asked who's been an inventor. You probably know all about your boss telling you to write it in your engineering notebook, sign it, date it, witness it. Not that that isn't a bad idea anymore, but it's really not going to get you anything anymore because we're not going to be worried about invention dates, we're going to be worried about filing dates. This is going to come up, I'll talk about this in a second. Publication dates are also going to matter, and it will affect possibly the strategy on the front end prior to filing a patent application. There's also a new thing called derivation, which is if you disclose it to somebody else and they derive a patent filing from what you gave them, you might have some recourse. Okay, so that's what we do. So Rick mentioned this real quick, but the basic requirements for a subject matter to be patentable is it needs to be novel and non-obvious. Okay, novel meaning, strictly speaking, it's not been done before. That's what most people think of when they think about patents, something that's new. But beyond that, it can't be an obvious variation of something that's been done in the past. That's in the existing law. That's in the new law. That's not changing. Okay. So here, it still must be novel and non-obvious. The first inventor to file system is being implemented mainly by redefining what's considered prior art. So the prior art is what the examiner looks at when he's trying to decide, is your subject matter novel or non-obvious? Okay. So what the new law does is it really opens up the gates and says pretty much everything prior to your filing date is now prior art. We're not worried about your invention date, we're worried about your filing. So here's the new definition. And I paraphrase some, but this is in the law. Available to the public. So virtually anything that was not derived from your own work, available to the public prior to your filing, is available for the examiner to say you're not deserving of a patent. Okay, and since it's keyed off your filing date, if it's anything prior to your filing date, it really opens up what's available to the examiner to say what's prior art. Patent application filings by others are deemed prior art as of their filing date. They're not published right away, so you might not see them right away, but by the time the examiner picks up your patent application and takes a look at it, he's going to have access to these other ones too. He'll use that as prior art against you. There's nothing in the new law about invention dates. The current law that exists today is kind of convoluted when you read it, because there's a lot of stuff about your invention date and whether you were diligent, whether you reduced it to practice, and whether something can be used as prior art against you based on that. That's all gone now. It's all about filing date. So what I thought I'd do is just go through a couple of quick scenarios and look at the way the old law worked, the way the new law worked, and what that might mean to you as an inventor when you're trying to decide what should I be doing after March of next year. So here we have two inventors. They both invented the same thing. It's identical. My little envelope is filing in the patent office. That's to get the patent. That's no patent. By the way, that's my grandfather's spark plug patent from 1935. Okay, so in this scenario, inventor A invents first, files with the patent office first, and the result is the same in existing law and after the American Invents Act takes place. So A wins now because he invented first. He will win after the AIA because he filed first. So it's the same result. Uninteresting, but instructive. So this is where it starts to change. Still two inventors, invent the same thing. A invents first, but B files first. Now, in the existing law, A would win if he could prove that he invented first. In the new law, these dates don't matter. He wins and he gets the patent. So, invention dates don't matter. You know, can we rush to the patent office? That's a good question. This is the grace period that Congress just couldn't give up. So if we have two inventors again, B files first, And in the last scenario, he won because he filed before A. But here, A publishes before B's filing. This becomes prior art to this, the day it's published, in the new law. Okay?
Define public.
Publicly available. Who asked? The prior art definition is pretty much anything publicly available.
Yeah, what constitutes published? Published on a patent or a piece
It could be, in today's world, it could be anywhere. It could be on a blog. It could even be offered for sale. It could be in commercial use. It doesn't have to be in a trade rag. It doesn't have to be in a patent. It doesn't have to be in a patent application. They're really broadening it now, and they're basically saying the new law has a list of things that says what can be prior art, but then it says, or otherwise available to the public.
Even on the shelf in Afghanistan in the library, right?
That's true, and that's another point, is that now it's in all foreign countries. We used to be limited geographically, and that's no longer the case.
But you have to what extent you have to disclose, like how much of your patent you have to disclose in the publication?
I don't know that there's a clear answer for that yet.
I would guess pretty much everything you're claiming.
Everything you're claiming, that's correct. But whether you have to disclose it in a way that will teach someone to have this invention, like Rick was saying, is a requirement for your patent to issue, it's not clear.
So publishing, what it does, not necessarily how it does it.
If you're publishing on purpose, and there is a reason you might want to, and I'll touch on that in a second, then you probably would want to publish as if you were just putting everything out there. The same thing you'd have in a patent.
So why bother with a provisional patent if you can just publish?
That's another good question. This, and I got another slide, but I'll touch on it real quick. This, it's prior art to everybody else, but it also is potentially prior art against you in foreign countries. Okay, there's a lot of foreign countries that have an absolute novelty requirement, and if it's out there anywhere, then it could work against you. Another reason you might not want to is if you publish this for this purpose, or for any purpose really, if you publish this, and this guy's hot on your heels, and he sees your publication, he could immediately, the next day, publish 10 variants of that. As of that date, those are all now prior art against your filing 2 days later. So you have to decide, am I doing follow-on filings? If so, I don't want somebody out there building a walled garden around my recent publication. But on the flip side, if you're a strapped entrepreneur, there's no way you can afford a patent, and you just really got to get a date down now, maybe publications are good. Yeah.
Published.
Okay, and this is another slight wrinkle that's in the new law. This is new. It's called derivation. So here, B is actually not an inventor. Okay, A is the only inventor here. He discloses to B. B files. If this inventor, even though he filed later, can show that it was derived, then he wins. All right, that's new. There's going to be new proceedings in the patent office for patent applications, and actually in the court system after patents are issued, if you can prove derivation, then you win speaking of patent. This has implications for what you might want to do when you're disclosing to others, right? Now, instead of being so worried about your witnessing in your engineering notebook, you're going to be wanting to witness exactly what you've been showing other people when you come into your company. So real quick, we've touched on some of these already. So scenario 2, why do we care? B wins because he was first to file. Well, the invention dates no longer matter in the first two analyses. First to file, first to publish, first to invent. There is no first to invent. Best practices inside your company, and is it a race to patent office? It might be, but it might not be realistic for some small entrepreneurs to just be racing to patent office. So scenario 3, A wins because first to publish. And one thing I didn't mention before is that the 1-year grace period comes in. The only way A is going to get the patent is that if he files his patent application within 1 year of his publication. So this is a question that's been bandied around on a lot of blogs. You know, do we now have a first to file with grace, or do we have a first to publish and then file? Right? Because if you want that to be your strategy, publish, right? Idea, publish. You got a year to file, no one else can do it. It's prior to everybody that they do it. So does this create an incentive to publish? Well, potential pros for publishing becomes prior art to all others in the publication. It's a strong offensive tool to bar others from obtaining patents because of that effect. Although the new law does have some expanded prior user rights, so if you're worried about having freedom to operate, if you're already operating, you actually have some user rights that would be expensive to enforce at a later date, but that might be a reason why you wouldn't want to publish. So publishing cons, and I mentioned this before, you can quickly publish variants effectively, creating prior art. You asked about provisionals, is that you? A publication is not going to give you a priority date. It's only going to start your grace period. Okay? And it potentially will almost certainly will create problems for you in foreign countries. If you file a provisional with the exact same content, then you effectively get the grace period of the year, right? You do have a priority date now. So any future filing will get the date of your provisional, assuming your provisional is written on that. And if you end up with a utility application that files priority to the provisional, so that the provisional becomes published sometime later, it will be prior art to others. Okay? But if you let that provisional die, it will never be published and it will never be prior art. Also, you know, for a small company without much money, if you publish something, it's prior art to the day it's published. You're not going to have to spend any money to get that in front of an examiner or to get it looked at for prior purposes. If you have to wait way down the line and try and bring up some provisional patent application, potentially it's going to be a lot more troublesome than actually. So scenario 4, A wins because B derived. Why do we care? Well, A must prove derivation. So that means that you might want to change the way you operate if you're going to be disclosing your ideas before you either publish or file a patent application. Instead of invention date record keeping, we need to be paying attention to whether we disclosed it, to who, exactly what, when, all the contents. And here, if you this could be your strategy. You file or publish before you ever disclose anything, and derivation is not going to be an issue. So what do you do before March of 2013? Talk to your patent attorney, and then just take a look at what you're doing inside your company. Look at your engineering notebooks. Maybe all the effort that your engineers put into signing and dating and witnessing everything should be put somewhere else. It's probably still a good idea to get everything down, but you don't have to be quite so militant about getting everything witnessed. Decide whether you want to publish. Filing strategy. It's really a discussion about best practices prior to that. There's a lot more changes in this law. I picked first to file just because that's the biggest one. Real quick, there's new post-grant review proceedings for when patents have already issued. The USPTO now has expanded fee-setting authority, which means costs are going to go up. There is a new micro-entity that will give you a 75% discount, but you can only have like 5 patent applications. You've been around 5 previous patent applications to take advantage of that. You can get a patent in 1 year, or at least take it all the way to the end of the process in 1 year for an extra $5 grand starting in March. Yeah. There's a new virtual marking statute which says that you don't actually have to mark your device with the patent number. You can actually put a website address and then have the patent number somewhere on the web. There's going to be new satellite offices for the USPTO, Denver, San Jose, Detroit, I think one other. And there's some litigation changes they've made, and many more small changes. And if you're a glutton for punishment, there's lots and lots of detail in these websites.
one of the key questions an entrepreneur faces is, do they launch the product before they file the patent or not? Is that considered publication? And what are the nuances around it?
Basically, if you've been involved in this process some in the past, sort of rule of thumb, if I sell it or talk to somebody, I got a year, right? That's pretty much still true if it's what you've done. So it acts like a publication. It will become prior art to others immediately. Of course, if you offer to sell something, it's going to be difficult to prove exactly what you offer as opposed to just publish something. But if you take one of those steps, you have a year before it's going to cause you problems.
I have a question. With the new law taking effect, will it only impact patents that are filed after the new date, or does that apply to anything that's sort of in
These
process?
provisions that I just talked about, the first to file, are for patents that issue on applications filed after March of next year. There are many other things that have already taken effect, but what I just described takes effect next March.
The small company, how do you actually protect against, what's the best defense protecting against patents?
I think that's a good segue into Everardo.
The one thing
The one thing I will add, though, on that question about whether to sell your product before you file a patent, you have a year in the U.S., but when you sell your product, you may be immediately killing any patent rights overseas. So if you're planning to expand overseas or protect it overseas, that's something you have to be very aware of. That has to be part of your consideration and strategy.
Thanks.
That reminds me of a case. It seemed like the first time I sat at the patent bar was it public display? I think it was like a women's undergarment or something, where it was like, it's not really on display, but it's for sale. There's all these nuances to this. We saw it before in a couple of slides, right? You really, 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 really want to use an attorney, okay? These are